Okay, good evening from Singapore and from the International Center for Dispute Resolution. And thank you all for joining us today for this session on emerging issues or emerging trends in alternative dispute resolution. My name is Michael Peer. I'm a partner with Control Risks. I sit both as an expert witness on issues of accounting and damage quantification, and also as an arbitrator. Let me turn over to Jen to introduce herself.
Thank you very much, Michael. Hi, everyone. It's a pleasure to be here speaking at this event today. My name is Jennifer Lim, and I'm partner at the Singapore office of Sidley Austin LLP, where I practice international arbitration and transnational litigation. In connection with arbitration, I also engage in mediation, so that's in connection with arbitration, and I sit as arbitrator as well. Over to you, Michael.
Hi, I'm Michael. I am the Vice President of AAA-ICDR, responsible for our Asia region. I'm also the head of our case management center here in Singapore. And this happens to be my office, so
Wonderful. As clients become more sophisticated and demanding, we're going to see that practitioners who manage to keep up with the technology are going to have a better opportunity to be able to attract clients and retain clients, I think. So what we want to talk about today is what do we see coming down the pipe, and how are we going to use that technology to better service our clients? Okay. Clearly, in the last couple of years, everything online has grown with leaps and bounds. We've not been able to get out of our houses. We've had to do things from our bedrooms. We've not been able to get onto a plane and things like that. So the first topic that I really want to talk about today is the use of online dispute resolution and mechanisms like using some of the digital tools, some of the platforms that are out there, something as simple as video conferencing, online mediation, online arbitration even. Perhaps, Jennifer, I could turn to you first for your thoughts on what we're seeing in that space.
Definitely. I think Michael's observation that online anything has really just grown in leaps and bounds over the past few years is obviously right. That was necessitated by the pandemic, but even as the world moves past that, I think online dispute resolution is essentially here to stay. The good thing about what happened in the past few years is that it's really encouraged wider acceptance of its use. So before 2020, it might have been more unusual to have video conferencing for hearings or procedural conferences. And I found that sometimes pre-hearing conferences and procedural conferences would have to take place in person, even where the parties and the tribunal members are located in different parts of the world. So obviously, even for more minor conferences, there would be a need for logistical arrangements for many of these people to gather in person. But now it's a lot easier to just convene a pre-hearing conference by video, and that I think is a lot more flexible for the parties. It's obviously cheaper for the parties. And when I say flexible, I also mean if there's any need to reschedule, it can also be rescheduled on much shorter notice and essentially at near zero cost. There's also increasing acceptance of the use of online dispute resolution for essentially substantive hearings. I think as people get past the pandemic, we are seeing an uptick again in in-person hearings. And to be honest, I think a lot of the clients that I have still express a preference for that because perhaps video conferencing hasn't quite gotten there yet in terms of emulating the in-person experience for substantive merits hearings. But that said, I think that could very easily change as technology increases. For example, with virtual reality, perhaps as a viable alternative to an in-person arbitration. This certainly could bring advantages in cost savings and of course in just convenience for the parties.
We're all going to need our avatars then.
I think you're going to need an avatar that looks like you, holograms or whatever we see in the movies. I mean, the nice thing about technology is that people have imagined what the world could be, and I think sometimes as lawyers we tend to see how the world is and how we're used to doing things. But if we're happy to, and if we're more willing to take on how a hearing could be run, right? Then I really could see this virtual reality kind of arbitration hearing taking off.
And I think you're right. We're going to see a lot more of the administrative matters taken care of online, remote, maybe some of the less significant witnesses and things like that as well. Yeah. Michael, your thoughts?
Yeah, I think, well, first of all, if I get to choose my own avatar, I'm not picking this. Something much younger and better looking. But I want to approach this on an institutional level. So ODR, as you mentioned, is a big term, and it sort of has every component in it. And whether we had pandemic or not, we were going there anyway. So the movement towards the online dispute management, case management system, cloud, storage, all those things were moving in that direction anyway. However, when the pandemic hit, we had no other option but to move in that way. What we had experienced was quite unique because we were dealing with about 300,000 cases per year in the United States and about 1,000 cases internationally. So we're dealing with a lot of arbitrators that are old school. So right away what we realized was these arbitrators still demanded paper filings. So I need bundles. I need bundles. Don't give me CDs. Don't give me files. Don't send me iPad. I need bundles delivered in my home address. So we were dealing with that. And then there were security issues when they were using laptops. Mm-hmm. So we had to have them bring in their laptops and then install, a lot of the anti, scan, whatever those things. And then, even before pandemic, there was the submission of evidences in a attachment, as an attachment. And then where do we store them? So from an institution perspective, first of all, what we had to do on our side was make online filing easier. But then we thought to an extreme, saying if this can be managed online, maybe all things can be managed online. We were wrong. It can be managed online to a certain degree, but then we still need to get on the phone, have to have the call. So even though we had systems ready for online case management, it helps to a certain degree, but not fully. And I think it will stay that way in terms of the trend. There are some other institutions that are still manual. So we're dealing with industry, the legal industry, which is sort of conservative, not too quick to changes. And as Jennifer mentioned, and as you mentioned, we're forced to take virtual hearings. But those pre-hearings were taking place on the conference call anyway. I just wish that I had bought Zoom stock in 2019 and then sold it a few months ago. But I think we were going there anyway. So we had to create a whole lot of systems pre-pandemic to create online case filings. And then the cloud server became a problem. Dropbox, OneBox became a problem because of where it's being stored. If it leaks, who's going to be responsible? So we had to create our own Dropbox. So I think we're moving there but before, compared to before, we're moving there a lot faster.
And that's fair enough. I think we've all been forced to do that. I think, you know, necessity is the master or creator of all, you know, invention, etc. But I think one of the difficulties that I've got is making sure that this is still a fair process and that all the parties still have access to it. And you mentioned some people still preferring to have a hard copy. But I think there's some areas of the world where we don't see the stability of the internet. We don't see the speeds. We don't see the technology equipment in place and things like that as well. So I think one of the things that we need to be careful about is to make sure that we're still getting a level playing field. You know, this is very useful and effective technology. It lets us be much more efficient, much quicker. In many instances, if we're beginning to introduce some of the AI algorithms into it, we can get the parties to come to a fair outcome guided by that. So getting rid of maybe some of the bias that's in there. But I think the fairness, the transparency, and the accessibility are things that we need to keep in mind as we go forward down this path.
I think, Michael, your point is extremely important because what we don't really publicize or we don't talk about is the small amount of disputes.
Mm-hmm.
We get a lot of them, and there are millions of them. We've had recently a $4,000 claim. It cost the claimant $27,000 in arbitrator's fee.
For a $4,000
Yeah.
claim.
For $4,000 claim. And so arbitrators said, I need my compensation. And then the claimant said, oh, even though I won, I can't pay because I didn't win anything. And then I had to pick up the phone and call the arbitrator, you're not going to get money. And then the arbitrator was upset. Why not? Because you're billing a ridiculous amount. There are a lot of smaller claims, and if we do it in a traditional way of person handling all those things, there's no way we can bring down the prices. So for efficiency, that could serve justice to a smaller number of small amount in dispute, I think that's necessary.
Yep. And that brings us nicely on, Michael, to the other technology that's out there now, not just the platforms, but rather the artificial intelligence, the machine learning that we're all beginning to experience and work with, and the ability to automate document production, redaction, that kind of thing, that should make us more efficient. But where do you see that going? Let Michael.
The AI?
Yeah, I think. Well, let me take a little bit further then, because I think, you know, we've now got the ability to, for instance, predict the outcome of a case. We can feed the algorithm with enough prior cases. We can give enough specifics about the case, the key points, and with a reasonable level of accuracy, the system can now say which way an individual judge will rule. Now, obviously, when we're in tribunals, that's more difficult because then you have to start talking about how the individual tribunal members will interact and how they will influence each other, and, you know, whether there will be domination or, you know, what's going to happen within the confines of the deliberations. But I think it does give our clients a huge insight into what is possible outcomes, and therefore, you know, how they might want to settle or to make more informed decisions about, do they want to proceed and spend the $27,000 in order to settle a $4,000 case. Now, obviously, it's not always accurate, and so, you know, there may be times when the machine is telling us differently. But maybe, Jennifer, if I can turn to you about that and ask about some of the technology that you're seeing in your cases.
Sure. Well, actually, I would like to follow up on a point or respond to a point that Michael on my left said earlier and relating to this $4,000 claim, because I actually think it's for these small value claims that would be ideal for essentially resolution by AI. That's being done in China, I believe, in Hangzhou. It's been done actually since 2017. So when we say emerging trends, I think what we're really saying is that that things are going to continue to change at a much faster pace. But it has already started taking place in some parts of the world. I think China's one of the biggest ones, but it's also being done in Estonia, I think, in part to kind of take away some of the workload of judges in dealing with some of the smaller cases. And I think the statistics for the Chinese courts online, they call them internet courts, are pretty staggering. I mean, in Beijing, apparently the average duration of a case is 40 days. The average dispositive hearing is 37 minutes, and 98% of rulings are accepted without appeal. But if you wanted to appeal, you can still appeal to a human judge. So by these internet courts, what happens is you have essentially this avatar-like, virtual judge, completely AI, that asks questions that you would expect a judge to ask, like, oh, do you have any objections to the evidence that's been put in by the parties, to rule on those objections and to issue a ruling. It's, to me, pretty impressive. I'm not sure I would still trust that kind of technology at this stage for any of the cases that are considered to be more high stakes, but maybe for some of the lower value cases where it really doesn't make sense to spend that kind of money, the cost savings that you could get from this would outweigh the potential for an outcome that you don't like, which in any event, again, you can appeal to a human judge. Apparently Estonia, they're doing that as well. And I think in the US there's been reports about a company that has an app that allows people to challenge their parking tickets with the help of AI. Do not pay, it's called do not pay.
Do not pay, but that's the one that all the judges, the lawyers have gotten very upset at because it's providing legal advice without a license.
Exactly. So of course, the way that we currently conceptualize the practice of law, the way our professional rules of professional conduct are kind of constructed, we're going to need to figure out how to adapt that to deal with these emerging technologies. I mean, I was actually surprised to read recently that as recently as maybe 50, 60 years ago, maybe a little bit longer than that, but definitely within the past century, in the US, lawyers were not allowed to advertise their services. I was just like, what are we all doing now? What's everything going on now? Like, it's again, I think once there's a mindset shift, you could always adjust your rules of ethics accordingly. So for small value claims, I think I think there should actually be more uptake. There's no reason why a small claims tribunal here, for example, couldn't use a little bit more of AI to assist with the resolution of cases. But as to your question, Michael, on my right, that was a very long-winded way of getting to your question. What I have seen with AI and how that helps is, well, I don't know actually if it's AI. I think it's litigation analytics, right? You want to look at any particular judges or arbitrators' history of deciding, both the kind of cases as well as how long they take to decide those cases, and that can give you more information to be in a better position to estimate how long it's going to take to resolve your dispute, how much it's going to cost, and really what are your chances of success with this particular judge. Usually it's a judge because judgments are public. And with arbitrators, obviously, we have to rely on our kind of internal institutional knowledge, but we can still use the information that we know collectively to come to these kinds of more informed estimates for our client. We also use AI in AI-assisted document review because now with data, with more data essentially being on the cloud, on mobile devices and everything, there's just a lot of data when you collect something from clients, and it just wouldn't be possible, I think, even if you had unlimited resources to have attorneys review each and every one of them. So what we do is we use AI-assisted review, which is, as humans review the documents according to, say, a protocol, and they tag the documents accordingly, AI is kind of learning how the humans are making the decisions and figuring out the patterns, and then pushing up documents that they think could be more responsive for review. And I think as more and more of the responsive ones get pushed up accurately, it continues learning that way. So it's a bit of an iterative process where I guess the review is still human, driven by the humans, but the AI significantly makes it more efficient.
Yeah, there's a lot of that sort of machine learning
Yeah.
coming in now, where it's trying to float the more responsive documents to the surface quicker.
Yeah.
So you don't have to go through everything because you found enough in what you're looking at in the first batches. But it does become then a question of, have you found everything, and is it fair, and things like that. So, Michael, your thoughts?
Yeah, I actually thought about this quite a bit. And I have created some for arguments and against arguments at the same time. We'll get to that a little bit later. But I want to share a story. It's about a tool. Once upon a time, when I was in school, in math classes, I'm sure you have experienced it, we were not allowed to bring calculators because we were supposed to do everything. And then, in college, we were forced to buy a calculator with all the formulas. So the tool, if you give a human the tool and then limit the usage of it, that's dumb, because we will find a way to use that tool to an extreme. So AI is a fascinating tool. It's scary.
Mm-hmm.
It could be scary good, or it could be scary bad. Even before pandemic in Korea, they fed the machine a lot of winning arguments. And then once they fed enough arguments, they created other situations. And then AI was tasked to create arguments for. And then human lawyers were supposed to draft an argument against. And then they gave it to a judge. And guess who won? The AI won. So whether we use the tool, AI tool, for analytics to predict the outcome, it will be very useful for, especially for third-party funders. But I don't think it'll stop there. In a couple of weeks ago, I was attending a iTech Law gala dinner. And then before we got to eat anything, they gave us a horn. They said, we're going to give you 2 set of poems. And then your job is to sort of identify which one was written by AI and which one was written by human. The whole room divided into 2. One says, half the group says the first one, half the group says the second one. And then Asta, my director, who's sitting over there, I think she wanted to win. And then I told her that I think we're already lost. Because if the room is divided in half, then we're all confused. And then we weren't sure, even the ones that got it right weren't even sure that they got it right. If it's good enough to do that, then we go into another problem. So the school system that was on the CNA news are struggling because we have highlighted the importance of original ideas and original writings. But now with ChatGPT, the writing becomes so incredibly easy.
I wondered if we were going to get through this segment without anybody mentioning ChatGPT.
So, and now let me just quickly go over to sort of my argument for and against. I try to think of the perfect judge, perfect arbitrators, because we have to, as an institution, appoint a lot of arbitrators. And then we have to appoint them, and then we receive challenges. And then we have to decide whether that person's dinner with that party was significant enough to raise justifiable doubt for their neutrality, and then remove it. So we have to constantly go through their qualifications. And when you look at judges or arbitrators, you want them to be wise, logical, knowledgeable, less emotional, and hopefully no bias. On the other hand, the bad arbitrator will be emotional ones, and then lack of knowledge there, and then had a lot of personal favors over to a lot of people. And then when I describe the perfect judge, AI fit most of the criteria.
Mm-hmm.
So, and then I decided to, okay, let's just write down against argument first. So AI lawyers and judges know, because we're going to get there anyway. The no reasoning was that they're not human. They have no emotions. And if you feed them wrong information, they may be inherently biased towards a certain group. And there's no accountability.
Yeah.
Because if judge screws up, then we know who screwed up. But this one, we can't know. But I promise you, if you let the AI take the bar exam, you'll pass with flying colors.
Mm-hmm.
And I barely passed. But now, if you think about argument for AI judges and lawyers, there are a lot of them. They're efficient, they're knowledgeable, they consume knowledge like crazy, they have no emotion, they have no bias. They'll never be challenged. Well, to a certain personal. So I came up with a whole set of arguments, and then I went on ChatGPT. And then I gave a command saying, give me an argument for and against AI lawyers. He came up with better arguments than I did. So I said, okay, I guess you win. So whether it is right or wrong for us to originally write our arguments, because I don't think any of us has ever written a contract with a blank sheet of paper. We all copy and paste some. So now we're beginning to wonder whether arguments generated by AI on its face is wrong just because it was generated by AI. If the argument is terrible, but because it came from a human, we should give it more value. And then it'll keep pushing because it is capable of doing that. And then I wouldn't be surprised in a couple of years, me as an institution having to regulate it in our rules and guidelines because the community says this is just getting out of our hands. So that's scary, good and bad.
It's going to be very interesting to see to what extent these large language modules or models that they're using can replace, say, the tribunal secretary in drafting sections of the award and things like that. And then, of course, to your point of the bias, yes, the computer shouldn't be biased, but we've seen a number of instances where formulaic approaches have been taken. A form of AI has been applied to people applying for certain services, people applying for mortgages, etc. And the bias of the humans who trained the AI are then reflected and multiplied, and you end up with an even worse situation. So I think we have to be very careful about how some of this gets introduced and the controls around it to make sure that the basis on which it's being trained is sufficiently biased in both directions that it maybe comes out neutral, or that we try and eliminate some of the bias before it goes into the algorithm itself.
I don't know if you guys have ever tried ChatGPT, but at first I thought it could give me meal plans and my travel to India for 1 week. When I started really testing, the ability for it to analyze and give me its own opinion. When I said, give me an argument against, and now that I heard, give me an argument for it, I was just speechless. And then I'm wondering whether I will be able to tell if this argument was drafted by the AI or a real human, or should that even make a difference? So we will, I think, get there very soon, because there are some smart people, and our logic and rationale is sort of holy grail for the tech people to conquer, because they desperately want to conquer that area.
Yeah.
One kind of point I would like to add to that relates to this idea that a decision maker has to be logical, rational, not emotional. I might be a bit, biased here, but I do think that every kind of human adjudicator at least has emotions, and if you do not understand what the tribunal wants, how they are feeling about the case, right? It doesn't matter what kind of law you throw at them, they are going to find a way to rule in a way that they want to rule.
Yeah.
So I do think there's still that element of emotion that, maybe if and when AI could get there, that's still something that it cannot quite substitute. And even in the, example of the internet courts I mentioned earlier in China, the Supreme Court, I think, recently issued a directive, and they made it very clear that AI was still to play a supportive role. It's not to replace the judicial function of the Chinese judiciary. That's just what I wanted to add to that point.
But at least we hope the computer doesn't have a bad day and rule
True,
against you
yes, and
because he
that's-
got out on the wrong side of bed.
Yes, that's when it gets scary, right? When statistics show, depending on how close you are to your election cycle or how close it is to lunch, you might actually rule against a defendant in a criminal case. Things like that, yes. Humans are very flawed as well. But in terms of the resolution of disputes, the development of the law, I do think that as essentially societal morals and views evolve, the law needs to evolve as well. And I'm just not sure AI is kind of, they might be able to in the future. But, if and to the extent AI is still based on historical data as opposed to kind of predictive, well, I don't know actually if they're going to be able to evolve in the same direction as or at the same pace as human society.
Fair
Well,
enough.
I think number one rule in marketing is appeal to emotions. And that's what Nike tries to do, that's what Apple tries to do, because we make decisions on emotions, and then we justify it with logic. And then if you ask a lot of arbitrators about their decision-making process, as Jen says, they decide what they want to decide, and then use the laws to support it. But the law shouldn't be. The law should be predictable. That's what the law is. Everyone should know what the consequences of the law if they disobey. So it has to be predictable, but then we make decisions on an emotional basis, and then use the logic to justify it so it reads better as an award. So I'm going to be controversial and say AI decision may not even be that bad. And we may not even be able to tell the difference later on.
I think as long as it's guided by the principles of fairness, of transparency, of accountability, yeah, I think it can do a good job. Maybe better than humans, ultimately. So, why don't we move on to mediation? Conscious of time. So, Michael, let me turn to you. I mean, you're sitting here as an institution. Is mediation becoming more widely accepted?
I'd like to say yes, but I'm not so sure. We have been pushing mediation for many, many years. And then we have seen so many different attempts at it. We have seen so many different variations of it. And it all comes to a perhaps devastating statement saying when it comes to international mediation, popularity of it goes down compared to domestic mediation. In domestic mediation, we take mediation as one of the mandatory courses of litigation. Sometimes courts force mediation of companies, and then their settlement rate is very, very high. But the moment you add mediation international in front of mediation, then different cultures and different things come into play. And we have been a big believer of mediation. We go so far as to push parties to try and mediate. 9 times out of 10, they say the arbitration cases, they say no to mediation. 9 times out of 10. And when we ask why do you say no to mediation, they say, oh, I don't want to waste time or money. So when it comes to international mediation, the thought is mediation equals waste of time and money. But that 10% who said yes, almost all of them settled. So the success rate is still there. And then we've seen multi-tier clauses. So the people got smart and say, we're going to mandate mediations. But when it goes to arbitration practitioners, they see that clause and they go, we've got to give mediation a try and then just get rid of it. And they fail, and that's so we can get to arbitration. So then we got smarter, and then we tried med-arb-med. So arb-med-arb. So you try arbitration, and then you stop arbitration, and then move on to the mediation. But then it didn't really resolve that concern of time and money. So what we decided to do was, okay, we have a better argument. So we start arbitrations. We don't stop arbitration. We'll start mediation on a concurrent level, parallel side, with a different mediator. And then if mediation is settled, can settle the dispute, then we'll just cancel out the arbitration, so you don't owe us anything. That wasn't enough. So we had to revise the rule. So we just did. We came out with the new rule. I think we may be the only institution that took that bold step. Now mediation is presumption, just like a lot of state courts. So if you have an arbitration cases, you presume that you're going to try mediation. Does that mean you cannot opt out? Sure you can. But now you have to expressly say, I'm opting out of mediation. We're hoping that will push parties to try and mediate a little bit more, but we haven't seen a dramatic increase of the number of mediations. So if your question was, is mediation popular or preferred method? Unfortunately not, but we're pushing.
Okay. And from your perspective, what are you seeing?
I agree that at present, it's nowhere near as popular as arbitration, but I think looking forward, the uptake of mediation is going to be essentially more widely accepted for a couple of reasons. One is, of course, with arbitral institutions pushing for it, including them in their rules, but also because of the Singapore Mediation Convention. Right now, there are only 10 states parties, so it's not going to enjoy a mediated settlement under the SMCC. It's just not going to be as widely or easily enforceable as an arbitral award under the New York Convention, right? But honestly, the number of states that are parties through the Mediation Convention is only going to grow. So, as it gets easier to enforce a mediated settlement, I think it's going to become a more attractive option to parties.
Yeah, because we've got 172 countries, I think, at last look on the New York Convention. But I heard UK is now going to sign on.
Yes, so they're going to sign, but you still need to ratify.
Fine. Yeah. Okay. Because I think what I'm seeing is one of the barriers to not so much mediation for me as much as sort of a commercial resolution to disputes is actually, what does a good resolution look like? And so you've got this dispute, you've got this monetary view as to what it should be worth if we were to prevail in court or arbitration. But what's it worth today? And so there's also a barrier then to going into the mediation room to find a solution because you don't know what you should be coming out with. And so I think we need to work more to find what that good outcome is, and to get whoever's in that room to get pre-authorization for a settlement. So with the legal teams, with the quantum experts, with the other people involved, get all the stakeholders to agree what good looks like. And then also what I'm seeing is people go into this as a horse trading. There's no negotiating strategy per se. They're not exactly sure what they can offer, what they can threaten to do. So there's not really that structured mediation going on. there's not that negotiation happening as to how do we get to something that we want. Because partly they don't know what they want.
So maybe, I guess, the more we are able to develop best practices around the conduct of mediation and the role of the mediator in perhaps, in informing the parties of their chances of success if they were to, duke it out in court or before a tribunal, the more people would accept mediation.
And I think the more, they don't have to stick their neck out. They don't want to recommend it because they don't know it. And they don't know what a good outcome, what a success looks like at the end of it. So if we can get everybody to agree what success looks like, and you can get into that ballpark, into that zone, then maybe people will be more accepting of it.
Well, I think, Michael, you're going to have to get everybody to agree on what mediation is supposed to be before talking about what good is supposed to look like. Because in Asian cultures, mediation sounds a lot like conciliations that we know, judges switching hats to mediations. And then as a mediator, they will suggest settlement amount.
Mm-hmm.
And then they're forced to sign on it, but they can opt out. But if they opt out, he immediately changes his hat and then writes a judgment according to that number. So, and then that sort of a conciliation model is prominent in Korea, Japan, and in a lot of other countries because they have statistics to show for.
Mm-hmm.
This is 99% settlement rate out of fear of being this same thing as being written as a judgment. So, but I have seen a good mediator versus bad mediators. It takes a very different personality compared to arbitrations and arbitrators.
Yeah.
And it requires a lot of negotiations, skill. I think that's why I was interested in speaking to Claudia afterwards. Good mediators will first of all set the scene correct. So ask the parties with authority to come. And then sometimes you get deadlocked. There's nowhere to go. And a good mediator can come up with some creative solutions or cool it down so save the dispute for the later date. So if we start categorizing mediation as an alternative to an arbitration, it may not get the traction it needs. But if we call it a assisted settlement, then all of a sudden the business sense plus legal sense comes into play. And then the corporate lawyers have a bigger role to play in it.
Mm-hmm.
And then they can do a math, and then where your analysis can come in, this is how much it's going to cost me to litigate you, and then there's only 45% chance of winning. So then all of that becomes a factor in business sense, not legal sense, but business sense.
Yeah, I agree. I think there's so many more options as to a solution when it comes to a mediated outcome, because you're not constrained by the legal ramifications and outcomes. It doesn't have to be a monetary value. It can be any number of things. So there's so much more flexibility and opportunity there. And it is, I think to your point, it's far more cost efficient than going. But, okay, just in the interest of time, shall we move on to our last topic? If there's any questions, please shout. So we've seen this desire for diversity, equity and inclusion, DEI, and even now we're changing that, or I'm hearing that's changing to DEI-A, which is accessibility as well. And we've seen a lot of campaigns. We've seen the campaign for equality of arbitrators in terms of gender. We're seeing a campaign at the moment, ERE, for equal representation of experts, for the promotion of female experts. What do you feel this effect is going, what is the effect of this going to be on dispute resolution going forward?
I mean, I hope that no one would ever say that arbitration is still, an old boys club, essentially, right? If the more people accept that diversity is actually beneficial to decision making, I think the more you are going to see diverse arbitrators, and it could be diverse across a whole spectrum of different things. The ICC, recently instituted a task force, for example, on disability inclusion, right? So I think it's really kind of causing people to think about the different ways in which we maybe unconsciously exclude people who are not like us in different ways. And by putting all of this, to the forefront of our minds, I think it makes people much more conscious of the need to ensure that there is diversity in any room when it comes to, well, any sort of arbitration or dispute resolution option, really.
Okay. Michael, you're...
Yes, diversity is a big issue. There is so many diverse type of diversity. There's ethnic diversity, there's gender diversity, there's so many different kinds of diversity. But if diversity is done for the sake of diversity alone, I think it's diversity done wrong. If we just include female arbitrators for the sake of meeting the quota, then obviously they will get rejected by the parties. We do have systems in our case management software where we are required to fill at least 30% of our list of arbitrators with the female arbitrators. And a lot of times we just have difficulties finding them because there's less number of them out there. But to afford them an opportunity to get better, if we just keep appointing them, then we may put the parties at risk. So I think it has to begin from every sector. It can't just be done by the institution. It can't just be done by a single or one successful female arbitrators. It has to be a community decisions to move towards some area, because the way it happened was a big pendulum swinging in one direction. So in order to swing it back, we need that much of a force to swing it on the other directions. I think it's coming on that direction anyway. Our former president of AAA was female. Our new president is also female. I wish that I have more gender equality at home, because I have a wife and 2 girls, so I get no voice. But in work, I have Asta and I have Pam. So they're all excellent people. If we can just afford them opportunity to prove themselves, they often are better than me. So we can achieve it, but the opportune moment has to be available for more.
And I mean, I fall into the male, stale, and pale category, so I have the strike against me. But I very much think that there has to be more diversity in terms of some of the technical training as well. And so, this is something that's sort of passionate to me, which is to have non-lawyers appointed as arbitrators. Because I think the diversity in the thought process as well comes from how you're trained, not only from the ethnicity or everything else. So I think, as you say, there's so many levels of diversity that need to be brought into this. So.
Well, you raised an interesting point about non-lawyers serving as an arbitrator. I think it's an excellent idea. From our experience, I see a couple of problems. What is the job of arbitrator ultimately? And then whether lawyer or not lawyer can do that particular job. I think that's the answer that we all need an answer to. So for me, arbitrator has one product, and that's the award. Mm-hmm. And that's the award. And the winners usually just go straight to the back, and then if they win, they don't read. It's the losers that goes through from the beginning to end, analyze everything to see if they can spot something. So you're writing an award for the losers. Mm-hmm. And if that's true, ability to write an award is perhaps the single most important aspect of being an arbitrator. What I noticed was there are a lot of technical experts who are not lawyers know a lot of technical stuff, but have a hard time drafting an arbitration award. On the other hand, arbitrators and lawyers know how to write one heck of an award, but they lack a lot of technical difficulties. So for now, the combination that I've seen was the technical lack of could be sort of fulfilled by the technical experts. But then award has to be written by the arbitrator or the lawyers. At least that's the general trends that I've been seeing. But I have also seen the non-lawyers with tremendous amount of expertise writing a great award. Just a couple of courses, just a couple of drafting courses, I think that should do. But there's always that fear from the lawyers when they're looking at non-lawyers about the final product. So I think we're going to have to find a way to overcome that part.
I might actually differ a little bit in my opinion,
Sure.
in that I think the arbitrator's role is to decide the case, is to resolve the dispute more than how they write it or how they, kind of frame it. And if anything, that's maybe where generative AI might be helpful in maybe coming up with a first draft for them to then work on. And so for certain types of disputes that are very technical in nature, I do think that maybe technical trained people sitting as arbitrators might be more qualified than lawyers, right? It's just maybe for the kinds of disputes I've seen, they're still legal disputes. So then it makes sense for lawyers to be arbitrators. But, at the International Court of Justice, for example, many of the people appointed as judges there are not actually lawyers by training, right? Even though they are still serving in that adjudicative function. So, and at least from, the way I see it, arbitration really came about from that kind of interstate dispute resolution process and kind of went into the private sphere. So why not, right? For construction disputes, having that kind of technical thinking could really, I guess, draw out and clarify the issues that are being disputed.
I think I would be remiss if I didn't put in a plug here for the Chartered Institute of Arbitrators as a training course to be able to write
Yes.
good awards, because that was certainly the most challenging part of that training when I became a fellow. But I think you're right. I think there are now going to be ways of compensating for that through tribunal secretaries, through the ChatGPT, writing first drafts and that kind of thing as well. So maybe we can see technology compensating and getting some more arbitrators in the pool and in the mix. So let me just make sure there are there any questions? Ask if there are any questions. Yes.
Yeah, I'm Judy Lau from your neighbor upstairs, Singapore International Mediation Center. Congratulations on writing in the presumption of mediation at the start of arbitration. You mentioned you've done that, but is it the take-up hasn't been very good? Is that because the parties choose to forego that option? Or?
First reason is because the rule is relatively new. And number two, I think it's more fundamental. I blame all of you for sitting here. And for the YouTube streaming people, I'm sure you can't see, but there are like a million people behind this thing. But it's the lawyers who get in the way, because international arbitration, at least in Asia, is such a specialized area. Only a selected few people can practice it. If you go to, not here, not in India, but if you go to China, Japan, Korea, there's only 5 firms that practice international arbitration, and within that firm, there's only about 15 lawyers. They charge a lot of money for arbitrations, and they don't want to mediate because they don't want the case to settle. I was invited to a reception, and then I met a good friend of mine, and he pulled me up, and he seemed very busy on his phone. He says, "You seem busy?" And I said, "Yes." And he said, "I have 5 cases, and I hope they don't settle." because that's the mindset of a lot of lawyers. He's been feeding us for the last 10 years, last 5 years. So the lawyers get in the way, the fees get in the way, but we still try. We're hoping that the new rule will generate some momentum. And then if we do it right, other institutions may adopt the presumption approach, and then it may become sort of a common thing to try and mediate. And then, but we also have to talk to the clients and then go straight to them.
If I may ask a follow-up question, to what extent then could we perhaps have conversations around the fee models? Because if someone is a good counsel and they are able to resolve a dispute very quickly for their clients, shouldn't they be compensated well accordingly for saving their client months or years of legal anguish? I know there's an argument about time-based models and people will be messing around with getting up and so on. But some lawyers also tell me that they do a lot of getting up pre-dispute and getting up to the dispute anyway. They are able to charge for that amount. Of course, we would trial as days of trial or arbitration. But shouldn't there be some thinking around the fee models that lawyers and perhaps there could be some uplift, to make it more, to incentivize the counsel? And it's like, very different skill sets. So my second other question is really to what extent is the lack of familiarity with the skill set as mediation counsel an obstacle as well, because they're just not familiar. It's a very different skill set from the adversarial power.
Well, about the fees, I think I'm going to defer to Jen, but at least for me, any good lawyers, the fact that they settled the dispute should be a reward enough, and that they have now a relationship with the clients, and they're entrusted with their disputes. So when there is a big jackpot case, then I'm sure that lawyer is going to get it, because the client then has a faith in that lawyer who has done everything in their power to settle the dispute, and that this is really a last resort. But I don't know how you create a fee schedule where you get compensated even if you settle, unless you do contingency plans or something.
So my view is that it might be the fault of some lawyers that mediation isn't more popular. I personally think that, if it's in the best interest of the client to settle a dispute, then obviously we would advise the client to do so. And we would be very happy to be either involved in the mediation or negotiation process, or if the parties want to do it directly between themselves, for them to do it as well. Ultimately, we want our clients to be happy so that, we can build that reputation as being a firm that looks out for the best interests of our clients. So I don't really see it as, if we successfully negotiate this, you're going to pay us extra, right, to make up for all the fees that you saved because we didn't litigate to the end, right? We see, or I see, arbitration or any sort of dispute resolution process as one of the multiple tools that a client has at his disposal for, if they were so minded for exerting leverage for settlement, right? There could be business, tools as well, but legally, these are some of, arbitration could be one of them, right? Clients don't always institute arbitration with the intent of litigating or dealing with it through to an award or enforcement, right? They start an arbitration so that they get the other party to come to the table. What I found from personal experience is that depending on the background of the client, occasionally they don't want to do a mediation or a settlement because they don't want to there's no one within the client who's willing to take responsibility for that decision to settle. They'll rather be able to say, it's the lawyer's fault, they lost the case for us, or it's the tribunal's fault, they ruled against us, they ordered, we have to pay this amount, than to say, we voluntarily agree to pay, even if it's a lower amount. We voluntarily agree to pay that lower amount. So I think that there might be some sort of cultural hindrances here that requires more education, or maybe a tweaking of the processes, right? If you have in place you take ideas from what happens in court, right? There was a settlement offer of X amount, and it could be without prejudice, save as to cost, right? And in the end, the tribunal issues an award that is for a lower amount than the settlement amount. The winning party would nonetheless be, perhaps should be penalized in costs for failing to accept the lower settlement offer. And I think if it became common practice for arbitrators or, to do this the way that's done in court, people would take settlement offers a lot more seriously, and they would probably be a lot more serious about mediation as well.
Okay. Any other questions? Yeah.
Eunice from the Financial Industry Disputes Resolution Center. I would just like to raise this a comment for your response, which is that although we see technology coming along and many other innovations in dispute resolution, but do you think that ultimately we will see much change? Because on one perspective, disputes are very much a human emotional thing, right? We know that by the time people have a dispute and it escalates to that stage where it's all about, dragging the other person down to the pit regardless of cost, no amount of reason or predictive analysis or even decision tree work will convince this person to drop the dispute or to try a more amicable form of settlement. Does this panel have any thoughts on this, and whether there is any prospect for a change in how we think of disputes? Yeah.
I'll give you a short answer. No. If everybody on this planet dies and there are 2 people survive, we'll still have a job. Because as long as there is 2 people, I think we will always have some sort of dispute and we can keep the job. The way we resolve it may make it wiser, it may be more efficient. But as long as human could resist it, there was always arbitration. Because arbitration pays far more than the court litigation. Because there's always needed an elder who's smarter, who's wiser, who will say you're right and you're wrong. Because these 2, you leave up to them, you fight to them. So the form of dispute will always be there. The way we handle it, we may wise up and better.
Okay, so in the interest of time, I think there you have it, really. Technology is not going to take our jobs away just yet. Hopefully it's going to assist us in delivering better researched decisions and get there quicker. Possibly remove some of the bias that's been in some of the decisions in the past. And maybe help us get a greater pool of arbitrators out there who can be assisted by the AI. So, thank you all very much for joining us this evening, and look forward to talking to those in the room over some drinks and nuts. Thank you very much.
Thank you.